G'day, I'm Stephen Page from Page Provan Family and Fertility Lawyers. Welcome to the Australian Family and Fertility Law podcast. If you're watching this on YouTube, don't forget to subscribe. We love our subscribers. Today I'm talking about some issues that have come up with the Department of Home Affairs that I've just seen arise. An American colleague said to me that there had been a trend observed by them, by colleagues who had Australian clients, of increasing paperwork over time, and that this increasing paperwork, these are for obtaining citizenship and passports for children born through surrogacy overseas to Australians. And that there'd been this definite trend of increasing paperwork. And here is an example of it. In the last year, I've been seeing a particular trend which only rarely came up in the past, but now it seems to be common. That the Department of Home Affairs, when it looks at Australian applications for Australian citizenship by descent, want to have, for children born via surrogacy, want to have paperwork of the surrogate's maternity records and birth records to confirm that the child was born. The birth certificate apparently isn't good enough. And they want a certificate of genetic affinity. And you might say, what's that? That's basically where the doctor says, I created, or under my direction, embryos were created, X number of embryos were created from this man's, so identify his sperm, and usually it's an egg donor, so whether it's an anonymous egg donor or a name, or it might be the other intended parent. And then on this particular date, one of those embryos was implanted into this surrogate, and therefore 39 weeks and 2 days later, a child is due. That's what's known as a certificate of genetic affinity, showing that this child was born from that embryo implanted into that surrogate. Sometimes it gets more complex when embryos are created, for example, in Australia, and then they're exported. And I saw one example where the department said, well, we don't have the certificate of genetic affinity, so that's a requisition. What they had was a letter from the doctor overseas saying, on this date, I implanted one of their two embryos of this couple, of their genetic embryos, as husband and wife, into this named surrogate. One of those took, and as a result, this child was born. Dated letter, on letterhead, with the stamp, didn't have his signature. So there was a criticism, didn't have the signature. And what did we have? We had a raft of documents showing that the Australian couple had created 4 embryos of their genetic material in Australia after a long and painful fertility journey, and then exported them. And we had the records from the clinic, we had the records from the courier company, and we had the records of the recipient-clinic. And yet somehow that wasn't good enough for the department. So I'm certainly seeing the Department of Home Affairs being particular and difficult in some of its record requirement. And what does it have to show? It has to show, if you're applying for Australian citizenship by descent, the child was born outside Australia on or after Australia Day 1949, that had an Australian citizen parent, and the child's identity can be established. So somehow these paperwork requirements seem to have become a journey upon themselves, but beware that journey, if you're an intended parent and you're going to be doing surrogacy, might be yours soon. So to be forewarned is to be forearmed. Thank you for watching and listening. I'm Stephen Page from Page Provan Family and Fertility Lawyers. This is Australian Family and Fertility Law podcast. If you're watching this via YouTube, please subscribe. We love our subscribers. Thank you.